to the City of Lakeland Code Enforcement Hearing Officer hearing. My name is Athena Warland, and I'm going to be serving as your hearing officer today. Before we get started, please silence your cell phones. Also, I'm an attorney at the law firm of Gray Robinson, so I would ask that you please bring it to my attention if your case is called and you are represented by Gray Robinson in any capacity. There are two ways we can address your case today. The first method is called summary disposition. Summary disposition is for those who are not disputing whether there is a violation and only need more time to comply. However, if you are a repeat violation, you are not eligible to receive summary disposition. We will address summary disposition cases first. For anyone who elects summary disposition and is given extra time to comply, the potential fine for non-compliance would be $30 per day for each day of non-compliance after the extra time versus the normal $50 per day. The second way we can address your case is by hearing your case. This method is for those who are disputing whether there is a violation and would like to present testimony and evidence as to why they believe there isn't a violation. I would now ask for everyone to please stand and be sworn by the clerk.
Do you affirm the testimony you're about to give is the truth and nothing but the truth? Yes, I do.
We're going to start summary disposition. For everyone electing summary disposition, please form a line here in front of me. Disposition. Up here. Hello, what page number?
23.
What's your name?
They can't take summary because they're not the owner.
Okay.
Has to be the owner of the property.
The owner passed away. That's my parents.
They're deceased.
Yes.
Are you, either one of you, in charge of the estate?
Well, in charge of it would be the bank, but we're the ones that live there and own it.
Yeah, we can't do summary. It has to be heard.
Plus they haven't even showed up from the bank. So
Yeah, so the case will have to be heard. So you'll have to wait till your case is called because you can't sign a summary.
What's today was for nothing then?
If you have a seat, then we'll hear your case. Okay, since we don't have any summaries.
We're now going to start hearing cases. Page 8, case number LCE 23-00502, 901 East Memorial Boulevard. Morning.
Morning. Angela Kaiser, Code Enforcement Officer with the City of Lakeland. Case number LCE 23-00502. Address is 901 East Memorial Boulevard. The owner's listed as Lakeland Town Center, LLLP. The violations of Section 86-4 for offensive liquids prohibited on streets and public places. Date of the violation is February 8, 2023, with the correction date being the same as this case was opened as an irreparable and irreversible damages cases that could not be corrected. Reinspection was the same day. To shed a little light on what this case is referenced to, on February 8th, we were notified that a large deposit of illicit material had entered Lake Parker. We were notified by a city worker who was driving by the area and noticed it. Upon further investigation, the pathway led back to the property of 901 East Memorial Boulevard. We found the first site of illicit discharge was this mural that was being uncovered. It had been painted over, and the property owners had a contracting company out there that was pressure washing the paint off and using stripper materials. They did not have any BMPs in place, which is best management practices, to protect the storm drain inlets or the drains in the parking lot, which would allow any of that fluid, any of those chemicals, and any of the old paint from going into the storm drain system and thus flushing into Lake Parker. Additionally, with further investigation, we found a second site of discharge. The second site of discharge actually came from the property had hired another contractor to add a roofing paint compound on the roof of the plaza there. And when they did that, it rained right afterwards, and the paint material had not dried properly. So it all washed down the sides of the building and through the parking lot into the drain system and ultimately into Lake Parker. So she's gradually going through pictures, but there's a lot of pictures to this case because there's so many. What this is showing is the discharge from the original paint going down through the parking lot and to the drain system. You can go a little bit faster with those pictures. So this led me to, we made contact on the site with the property maintenance manager, and we walked the property. We discussed what was going on. We, discussed the evidence. We found the paint materials at the dumpster that they had used. We took pictures of that. We have attached a safety data sheet of that material to the case to show you the harmful effects of what that material is and does to the lakes. This is where it enters the lake, and the system where it entered is actually set up to try to filter out some of the discharging that goes into the lake there, because there's so much that goes in that area, but it's not designed to stop chemicals. It's designed to stop trash and larger items, I believe. And Lakes and Stormwater can clarify that if that's incorrect, because they are also here to speak on this matter. But this did affect a large quantity of the lake. As you can see, I have walked around the lake, in areas to take pictures to show how far the initial impact of this discharge was. And again, Lakes and Stormwater can go over how this material can discharge further than just this area. So what I'd also like to say is this is the third time that this property has been cited for illicit discharges from their property in the probably 4 to 5 month period that this case was opened. Previous cases were LCE 22-07299, which was a case where a Chinese restaurant or a hibachi restaurant on the site was cited because their grease containment system in the back was leaking. They were notified of it. The plaza was notified of it, and the container had to be reordered so they could get a new one to replace the damaged one, so they had to wait for that. In the meantime, they did not take any measures to control the grease spill because of the time frame that it was taken care of in, and because we felt like it was a minimal discharge, the city opted not to ask for fines at that time. The next case that was within a month of that first one was case number LCE 22-07952, where another of their tenants was cleaning grease from their driveway and using a chemical. Because the city did ask for fines on that one, and fines were imposed on that one. So then, and both of those occurred in September, October of 2022. This case occurred February of 2023. So it's not like the property was not aware of this type of discharge and was not aware of protecting inlets and that kind of thing. At this time, I'm going to go ahead and let you know that the city is asking for a fine of $5,000 in this case, based on the amount of quantity, or the quantity of the discharge that occurred and the amount that impacted the lake. And if you want any clarification on environmental impacts, to include review of the material safety data sheet, then I can call Lakes and Stormwater up here so that you can see exactly how toxic this chemical to the lake system is. Okay, so I'll introduce Sandra Pope from Lakes and Stormwater, and I'll let her give you her title and all that. There's that.
Hello, good morning. My name's Sandra Pope with the City of Lakeland and the Lakes and Stormwater Division. So for this case, the immediate visual impacted area from the photos, as you can see, was approximated to be about 2.6 acres, which is 2 football fields. And that isn't contained at that point. Of course, it's water, so it's going to flow out even beyond that. But that was the immediate visual impacted area. The quantity of this type of spill can cause serious impacts to the lake that harm animal and plant life. It can contaminate their food sources and their nesting habitat. I did bring, as Angie said, the safety data sheet is attached to the case. If you'd like, I can present this to you. I've highlighted the areas that refer to the environmental sections. Would you like me to bring this?
Yes, please.
See it first?
That too.
Yes. This is the safety data sheet. Safety data sheets is a communication document required by chemical manufacturers that provide guidance to help workers who handle hazardous chemicals. And so within that data sheet, I've highlighted, if you look at the blue tab, what to do in case of accidental releases. And these are the measures that it refers to be taken, which you can see under methods and material for containment and cleaning up. It says to clean up all spills immediately. The next highlighted area, prevent by any means available spillage from entering drains or watercourse. The third highlighted area, to wash the area and prevent runoff into drains. And if contamination of drains or waterways occurs, to advise emergency services, which in this case would have been an environmental cleanup company. If you'll flip to the green tab, under section 12, the ecological information, on that next page, the first highlighted area states that it is harmful to aquatic organisms, may cause long-term adverse effects in the aquatic environment, do not allow product to come in contact with surface waters or to enter tidal areas below the mean high water mark, do not contaminate water when cleaning equipment or disposing of equipment wash waters. We are on the green tab. Next, it states do not discharge into sewer or waterways. The next highlighted section refers to one of the ingredients in this roof coating, which is titanium dioxide. The persistence is high, which means that once it is in the environment, it stays there. It does not biodegrade very quickly. When it states that it's high, it means that chemical will stay in that waterway for some time. And lastly, the last highlighted section says, do not allow wash water from cleaning or processed equipment to enter drains. And so the city spends millions of dollars every year to keep our lakes clean. As Angie referred to that pollution control device where it entered, that pollution control device has vaults within it, but the chemical quantity was so great that it overwhelmed that, and so it was able to enter the lake.
Is there any remediation that the city is doing? What is the cost of that if they are?
So unfortunately, once it's in the lake, it's impossible to remove that without causing substantial further environmental damage. So once it's in there, sadly, the best option is that it has to stay there. You're welcome.
Respondent will state your name for the record, please.
Yes, ma'am. Rod Finer, I'm an attorney with Coker and Finer, representing the property owner. And before I'd like to, I make a presentation or anything, I'd like to ask Ms. Pope some questions.
Okay.
Morning, Ms. Pope.
Morning.
Just real quick, you mentioned that the city spends millions of dollars on its wastewater structures and everything. Did this discharge damage any of those wastewater structures? Did the city have to go and repair them or do anything to those wastewater structures?
The structures,
Okay.
no.
You also mentioned pollution, everything. Did you see any wildlife negatively impacted? Did you personally observe any wildlife negatively impacted, like dead fish floating on the surface or anything like that, or dead birds in the area?
That's a very good question. Visually, no, but in order to determine environmental impact and damage to the lake would have required a team of scientists on standby to take water quality samples, to take fish tissue samples, and that sort of thing, which would, the cost of having that sort of team and laboratory would greatly exceed $5,000.
So the city didn't do any of that?
The city, no, we did
Okay.
not do
And
any
you
of
didn't
that.
personally observe anything else about wildlife being damaged or being deceased in the area?
Personally, visually, no, but my educated opinion of the type of damage that that chemical can do in the environment based on the safety data sheets and the studies that go into those safety data sheets, the damage is long-term, as it's stated.
Again, my question though, however, is visually, your own personal observations, you didn't observe anything of that?
Correct, and visually, as I stated, I did not
Okay.
observe.
And the same thing with the landscape materials in there? You didn't see any visual impacts to that besides the sheen on the surface? You didn't see trees all of a sudden start dying or anything like that?
This type of damage would take some time to visually see. However, I think it's important to note that these kinds of discharges have been illegal by federal standards since 1948, and then again in 1972 when they revised the Clean Water Act. So the reason that the federal mandates are there is because these types of discharges do cause damage, whether I can visually see them or not, or whether we need a laboratory to clarify that.
Again, just to answer the question that was asked, I'm in no coaching the witness, Your Honor. Again, just to clarify the question, and I thank you for your answer. Visually, you didn't see anything, correct?
Correct.
And the city did not do any testing to determine any of those long-term impacts, correct?
Correct, but are
Okay,
you?
thank you. No further questions.
Is it being suggested that because I can't see it with my own eyes, that no damage occurred?
That's not what we're saying, but I asked just a couple of questions, and then a hearing officer will make a determination.
You're welcome.
And I have some questions for the code officer herself.
Yes,
Morning.
morning.
We've spoken previously. So just so we're clear, and for the hearing officer to be aware, this is what we call in law, and you're familiar with general laws, right? A strict liability statute, right? And so for the education, it means regardless of whether the owner did it or not, the mere fact that it occurred, the owner is liable, right? All right. You don't have, and as you said during your testimony, I just want to clarify, the issue with the paint stripper, where they were uncovering the mural, that was done by a third-party contractor?
Correct.
And the issue with the roofing materials put on, that was done by a third-party contractor?
Material was put on by a third-party contractor.
Correct. A licensed roofer, correct? They had, when you saw
I
that?
do not know what their licensing was.
Okay. You don't have any specific evidence that the owners themselves did this or knew what was going on?
The property owner is ultimately responsible.
Again, strict liability statute, but besides a strict liability statute, you don't have any evidence that the owner said, just go do this and don't put best management practices or anything else there?
I don't know that they told them to put best management practices out there.
Okay.
And
And
I
then-
don't know that they followed up with them to see that they were doing such, since
Okay.
they already knew that that kind of thing was necessary.
Well, they knew that, well, we'll get to that in just a second. And then when you were out there, you spoke to the property manager on site, right?
the maintenance
The maintenance manager.
supervisor, yeah.
And there was still some material in the storm drains themselves when you did the inspection, right?
Absolutely.
And that material was removed by the owner from the storm drains almost immediately when it was pointed out, right?
Correct. After the fact, a few days after we went out there, they finally got a remediation team out there who did clean out their drain system, and they cleaned out any of the discharge all the way up to the lake. So through the stormwater system up to the lake, they did do that because we let them know that if it rained again and distributed the rest of it into the lake, that would be a secondary fine.
Understand.
That would be a secondary occurrence in a
But
new
the owner
case.
did act promptly and
They
try to do everything they
absolutely,
could.
right. After a few days, they got somebody involved. At first, they only wanted to do it on their property. And we said, well, what has left your property already and is still in the storm drain and not in the lake yet? Once that hits, that's going to be another occurrence.
So then
So then they decided to go ahead and go to the lake.
need to get permission from other property owners to go onto their property as well. to do that.
They had no, that was all DOT and City of Lakeland, so there was, because we were instructing them to do so, there was no other private property owners to contact.
Right. And then, so you talked about two other instances that were involved. One, it was a restaurant with a grease trap that was broken, right?
The grease container, not the
grease
trap.
container was broken. So it was a tenant that was on the property. And again, I understand the owner is
Yes.
ultimately responsible, but that was with the tenant.
Yes,
And the tenant didn't take the precautions necessary.
correct.
And then the second one was also with a tenant improperly cleaning their grease trap.
So yes, the first one was, and we decided because of the circumstances with it, we were not going to ask for fines to be imposed on it. So we did go lenient on it, even though we do believe that grease hit the lake system. The second, because of the time frame, the secondary occurrence, we did ask for fines to be imposed, and they did. We did ask for a low number on that one because we had no knowledge of exactly how much entered the system. So when we don't have the full scope of the quantity, we feel it's not proper to ask for large fines. So we went with the minimum on that case, and we were awarded that.
And the quantity you determined in this case was determined by the extent of the plume on the lake?
It was the plume in the lake, and then we found 2 5-gallon buckets of the material in their garbage container, or empty containers. Can you pull up the matrix?
Well, I'll object to the matrix, so I don't think it's,
Well, I would like to clarify for the hearing officer and for anybody present, and to get it on record, what our matrix
then
has.
before we do the matrix, let me ask you a question about that.
Sure.
Was that adopted by the city commission?
The matrix has not been adopted.
So that's an internal staff thing. I don't think that's relevant to the code or anything else in terms of assessment of violations of what they use internally as a matrix.
So we use it based on the Florida Department of Environmental Protection's matrix system, and we use the same standards that are set up by statute, which is all explained on the matrix. So we use it simply so that for every case, we can try to be as fair and consistent with, the type of product that has been discharged, whether it's soil and sediment, or whether it's paint, or whether it's oil or grease, whether it was accidental, whether it was on purpose, whether it was, could have been prevented, whether BMPs were used or not, if if the parties responsible should have had knowledge of such, et cetera. So we do, the environmental impacts that it could use. That's why we have that matrix in place, and that's why we present it on all of these types of cases, is to show that we are trying to make it as fair for everybody, for all the citizens, for all the business owners, for anybody that does business in the city of Lakeland.
Again, since it hasn't been formally adopted by the city commission or anything else, I don't think the matrix is relevant to these proceedings.
Or not?
In terms of what code enforcement uses to make their recommendation, if they use that to formulate it, they can use it to formulate it in terms of coming up with their recommendation, but I would defer to you in terms of whether you want to use that as evidence in your ruling.
Okay. I'll view it. Right now, I pretty much just want to hear from you if there's evidence that this didn't happen. I think it's pretty clear that it happened, so
So let me clarify the purpose of why we're here then, to clarify. It's a strict liability statute. It did happen. We acknowledge that. We're not contesting liability on that. The issue that we're here about, and the reason why I did that cross-examination, then I'll have my clients come up, is we don't believe a $5,000, which is the maximum fine that can be imposed by you today on an irreparable violation, is appropriate in this particular case.
Then I believe the matrix is definitely important to view then in light of that.
You will take it back to the top so we can kind of read through it. So this is what we use for illicit discharge irreparable damage violations. And the code enforcement fine assessment considerations are as follows. Fine amounts are determined using sound judgment and are modeled after the Florida Department of Environmental Protection's guidance document for assessing civil and administrative penalties. Fines are based on several factors to include, but not limited to, the egregiousness of the act, the ability to have been able to control the release but negligence in doing so, the hazardousness of the natures of the chemicals released, the inability to remediate, which is irreparable damage. And then you scroll down and you can see the chart. And so in the black, it discusses deviation from requirement, whether it's major, moderate, or minor. And then the breakdowns of numbers are in dollar amounts. In the red, you show the environmental harm, and again, you have major, moderate, and minor. When you're looking at the environmental harm in red, if you look under, there's the definitions for major, moderate, and minor. So major are violations that result in pollution in a manner that represents a substantial threat to human health or the environment. We would argue that this would be a major because people often fish, and when I say often, I mean almost daily, off of that exact structure where the material was coming through. So people are fishing out of there, catching the fish, and taking them home. I don't know if they're using them as pets or if they're eating them. So then you go over to deviation from requirement, and the major definition is the violator deviates from the requirements of law by a significant extent or the violation was willful and intentional. So in this case, while the property owner did not do the acts themselves, they also did not follow up with their contractors to make sure that they had the proper things in place, and this was the third time they'd been cited in a matter of 4 to 5 months.
Well, I'll save the matrix for argument at the end. There's no questions I'd need to ask the officer on that.
Okay.
Thank you.
Go ahead.
No, I was going to call witnesses myself.
Okay.
I'll call Mr. Sharabi. State your, right here. So first of all, state your name and indicate whether you've been sworn or not.
Not as tall as you. Sharon Sharabi, sorry for my voice.
Have you been sworn in?
I've been sworn in, yes.
What is your relationship to the property owner?
I'm the owner.
Okay, so
Property.
the prop-
Excuse me, real quick. Can you spell your name for them so we can put it on record?
It's Sharon like Sharon, Sharon. Last name Sharabi, Sharaby.
And when you say you're the owner, it means you're the principal of the limited liability, limited partnership that owns the property.
Correct.
Okay. Would you explain to the special magistrate about the paint stripping of the mural and how that occurred?
Absolutely. We were contacted by, I guess, the Harris of Publix, one of the representatives, and they said there's a mural and they're trying to uncover every mural from Publix. And we gladly agreed because obviously to maintain some of their historic murals I thought would be great. They sent the actual person who originally put the mural, or the company from California, they sent him down. And again, we don't know what they're using for stripping or whatever it might be, but obviously it's Publix. We figured they're a professional company, they know what they're doing. They showed us their insurance and liability insurance. And they proceeded by doing that. We had no control over or watched the process. It's not our job.
So just to clarify, the stripping company, Publix, asked your permission to strip the paint, is that right?
Correct.
You gave that permission, then Publix took over and decided the material to be used, who to hire, and everything else, is that right?
Correct. They brought him down from LA.
Okay.
From LA. Now, I know the elastomeric that you've showed, but what's in the storm drains, a repair, the material, nobody has checked to see which material went in the drains, whether it was the repair of the roof or the paint stripping from the revealing of the mural. They're assuming that it's the paint of the roof, but it has nothing to do with the paint on the roof. The paint is an elastomeric material that goes on the roof. You don't see anything coming down from the spouts showing that it actually came from the water spouts into the drain. It's more likely to be from the stripping of the mural, the way they did it. We've painted the entire property, 283,000 square feet, and there was never any spill from our part. So we are very, very wary of the fact when we do something within the building. We have completely renovated the entire building for a time of 6 months, and there was no issue whatsoever.
So when you were doing the renovations of the building to the tune of several $100,000, there were no issues with discharge when you were in charge of that?
100%. We've never had any issue.
Okay, now talk to the special magistrate about the roof issue, where you had a roof leak and then certain material was applied to the roof. Can you explain, what, if you know, what material was applied?
Yes, so obviously there's strong winds in Lakeland, and some of the hail guards from the AC can actually fly. And when they fly, they can create sort of a gouge in the roof, and the tenant had a leak. So when you repair the leak, you apply elastomeric on the roofing system. It's applied with a roller, and my opinion is that there was actually no spillage from the roof. It has to do from the stripping of the mural. So we've never been careless. Yes, there's accidents with grease containers, there's no question, but everything and every time that the inspectors do come to us, we tend to the items immediately. We deal with a lot of things on the property, there's a lot of homelesses that were before we bought the property, that it was dilapidated, and it was a lot of homeless people that are there. Everyone is great, there's no question, but we've had a lot of graffiti. When they send in a violation, we repair it immediately. We have 3 maintenance personnel on the property. We can notify the tenant as far as the grease, but nothing can be done extremely fast. You're dealing with companies, so when you order, it takes a couple of days to get a new grease container. Naturally, it doesn't happen overnight or the same day. The same when you call a company to come and do cleaning to storm drains, it doesn't happen the same second. You call them and they say, okay, we'll put you on the schedule 2 days later, but the second we got the notification, right away, we called somebody. Now, we didn't know, she said, as far as the cleaning, that it's not that we didn't want to clean all the way to the lake, it's just that we realized it's not our property. I can't enter someone's property. When they said, no, you can, so they spoke to the cleaning company, which is an environmental cleaning company, as they suggested. We sent him, I said, go clean it, we'll pay for it. But I cannot assume that I can just go into someone's drain and start cleaning their drain system. Now, even the company, when they came out, if you take a bucket of water and you put a drop of white paint, let's just say, that comes out, it's going to cloud the entire bucket, just one drop. There's a law in Judaism, 1 of 60th, meaning anything that 1% of 60th completely, you will see the impact of what happened. So the thing is that, yes, I understand there's a cloud. We don't know how much went from the stripping of the mural, but I can tell you that when they did clean it, they only charged us $1,700 because it was less than 1 inch of water of the material on the bottom that was already diluted in water. So I don't know, it wasn't done on purpose. I don't want to be portrayed as somebody negligent. We take very good care of the property. It looks beautiful. We have intention to even beautify it even more. We want to create the new Midtown. We work with CRA. We're building another 25,000 square feet with 8 restaurants. We're working with the incubator to also bring new restaurants 8 new restaurants from the incubator into the shopping center. So we're here to be good partners. We're not bad people. I don't want to be portrayed as someone's bad. We're very responsible. That's why we have 3 maintenance people on site at all times with a security company as well. So yes, things happen, I get it, but we shouldn't be penalized to the full extent of the law.
Since you've done this, do you also have a full, I'm sorry, usually that's not a problem. Have you also hired a full-time property manager for this, besides the maintenance people for the property?
Of course, from day one.
All right, and And since this case has come about and we realize what these issues are, have you instructed your property manager now when work is being performed to go and inspect all these items and make sure that best management practices are being followed so a situation like this does not occur again?
Yes, I did.
Thank you.
You have questions?
Thank you. I believe it's important to note that no cleanup activities occurred until the result of our investigation. Based on the volume of material that was in those storm drains, someone on site had to have noticed all of that draining into the storm drains.
Objection, speculation.
And so furthermore, Lakes and Stormwater gave the all clear for the environmental company to clean all the way to the lake. I'm not sure if your client can state whether or not it was his decision to only do the cleanup on his property.
They then did off their property as well. Okay, then that's not disputed. We've had testimony of that. That's the evidence that I would want to present. I do have argument to make. In this particular case, we think the appropriate fine is in the realm of $750. And here's why. There are a couple of things. One, we don't believe this was a major discharge, as they've characterized it under the matrix. If you even consider the matrix, it should have been if anything, it's a moderate discharge. If you look at the definitions of what it is, they're saying it's a major based upon their speculation on how you look at that. But let's look at the facts here. The facts are this is a commercial shopping center. We did what we were supposed to. The client hired, through Publix, they hired a licensed waterproofer who you trust that your contractors are going to follow the law and do what they're supposed to do. They're licensed contractors. It wasn't some fly-by-night person who came in, who we hired off the street to go do pressure cleaning. This was a licensed pressure cleaner, though there is no state licensing for pressure cleaners. When you have pressure cleaners, you presume they know what they're going to do, just like you have someone comes to your house, they do that. When they were applying something to strip paint, because that's what they knew they were doing under the supervision of Publix, we trusted those people to do what they were supposed to do. And if that meant putting sandbags or something down to stop runoff into the storm drain, we would have presumed that they would have done that as they were supposed to. Same thing with the roofer. And the roofer is a conglomeration of circumstances. The roofing material was put on, and later that day there were massive rains. 24 hours after, if it didn't rain, this one did not have been an issue. However, it is what it is. Again, though, we hired a third-party roofer to go and install that material. When they do that, they're supposed to know if there's possibly a rain, and maybe they put something down for 24 hours until the material hardens in case something like this occurred. They did not do that, but again, licensed roofer, licensed roofing contractor, we as a property owner say, you're going to do your job just like we trust you to do your job. It's no different than hiring a contractor and presuming that they're going to do the work according to permits. And when they don't do the permits, you have an issue with your contractor. We have an issue with what these people did. However, since we've now come to this and we realize this, we've implemented changes to ensure that this doesn't occur. We have the property manager on site who's now going to supervise all the work that's being done. He's been educated on best management practice. So he knows what has to happen when this occurs in the future. In addition to that, we've now incorporated into our contracts, because I wrote the contracts for all future work that's going to be done, so I know, we've incorporated language in there that says they have to incorporate best management practices to stop discharge to storm drains. I would argue that you really don't even need to have that in your contracts to begin with because it's the law already that you're supposed to do that. But as an extra precaution, I added a whole paragraph to that contract to make sure that any contractor who performs work on the center knows that. And the reason why we know that is when we repainted the center and we did a whole bunch of work that my client was in charge of, there was no discharge to the storm drain. So this is not something where you have a negligent owner or an irresponsible owner who says, I don't care whether material goes to the storm drain or not, and we'll do this. Let's talk about, the city may take issue with that, saying there were 2 other violations. Again, both involving grease, which is different than what we were dealing with here. Both involved tenants who performed actions at other times when we were not there. We can't be supervising 24/7. We've now educated all our tenants about this, but I would argue that those 2 other cases where there was discharge involved is substantially different than what this is, and the materials were substantially different. So I understand that there was some irreparable damage. They can't say what the irreparable damage is. They haven't observed anything. They didn't do sampling. They didn't do anything. They don't know the extent of the irreparable damage. It's based upon their speculation of what they think it is from what they think might be the material, but they're not sure whether it's the roofing or the pressure washing, because both were done at the same time. And they didn't present any evidence about the pressure washing material. That was just the roofing material that they added the matrices on, or the document on. So in this case, in the overall, taking the totality of the circumstances that are involved here, that we're on the hook because it's a strict liability statute. We didn't do it. We didn't do the work. We hired professionals to do the work, or relied on other people, publics in this instance, to hire professional people to uncover a mural which everyone in Lakeland was thrilled to be uncovered. And we said, go ahead and do that. The amount of the fine in this case should only be $1,000. And now we are on notice that not only, and I say this, we're on notice that not only have we instructed our tenants, but all future contractors, and we've taken steps to prevent any future contractors, any work who do this on the property from this type of event happening again. And if it happens sometime in the future after we've been on notice and we've instructed all our contractors and our property manager is out there supervising the work that's going to occur, I say have at it. But in this particular case, involving the facts and circumstance of this, we think a reasonable fine is between $750 and $1,000 plus the city's costs in doing this, and that's where this matter should end. $5,000 is the maximum that can be done. It really implies an element of bad faith or intentionality, and there's no evidence here of that occurring whatsoever. And so we think that in the exercise of your discretion, the maximum amount of fine is not warranted.
So I'd like to clarify. So at the picture that's up, to clarify, the mural is, okay, in the picture, if you look, you see Family Dollar where the blue is. The mural is to the right of that, and I believe it's even to the right of the Save-A-Lot, which is the gray. And the discharge, if you follow the arm in the picture, the discharge goes straight down that way towards Memorial Boulevard. So the mural is down scope of where this storm drain is. And if you'll go to the next picture, the next picture is inside that storm drain, and that is the material that came off the roof upstream from where the discharge of the mural was. So then I took pictures in every single storm drain going down through that parking lot to show that there is that material going all the way down, even past where that mural was. So the argument can't be stated that we don't know that some of their paint material entered, because we absolutely know that some of their paint material entered. We also, and for some reason I don't have the pictures attached, but on that property you could see the material raining, streaming down the walls because it had rained, and there was white streaks all down the walls, all on the concrete, all on the asphalt, going into their drains, which leads through this path. So there is no arguing that the paint material didn't also enter the lake system, and what was taken from the mural could not have had that kind of impact on the lake. So that's what we'd like to argue there. And then there was something else that, well, that's what I have to argue. Oh, and Sandra says she's got one more.
Thank you. I'd like to make one final comment. The environmental harm is not based purely on my speculation. It's based on the fact that this chemical is labeled as a hazardous material, as stated in the safety data sheet. Safety data sheets and manufacturers are required to do a large amount of study and research in order to determine the environmental impact for such chemicals.
The safety data sheets say may, right? It does. The one you introduced says may.
I'm not sure.
On the green tab, harmful to aquatic organisms may cause long-term adverse impacts. May, doesn't say will or shall, right?
It also states further in the data sheet that that chemical persists, has a high persistence in the environment. So what that says is that chemical is going to stay there, and the longer that chemical stays there, the higher probability that the environmental harm is going to be long-term. And that's purely based on the information in that data sheet. That is not my speculation whatsoever.
I would argue that is speculation. Yes, it stays there for a while, but again, it says may, and she's presuming that if it stays there longer, it's more likely to have an environmental impact or something else like that. That can be her speculation based upon what the word may means and its viscosity, but again, there's no actual evidence of damage occurring today presented at the hearing.
After the roof was painted and it rained, did they have to go back out and redo the roof?
Yes.
Okay.
And that, there was no discharge from that at all.
I'm just asking if, you know, when it rained, if it actually had to be done again.
Yes.
Okay. That's all. What is the recommendation of code enforcement?
City of Lakeland is recommending a fine of $5,000 be imposed.
How long to pay?
There is no payoff date. To clarify, that is the maximum amount allowed by law.
Violation, and I appreciate the evidence that the respondent has presented, that you don't have control over all of your tenants and your contractors. However, it is the responsibility of the owner to control the situation on their property. There were maintenance people on the property, as you said, you have 3 maintenance people. So the moment that something was observed that there was a wash off of a chemical that was harmful, things could have been done at that time. I do believe that it is within the matrix to fine for the $5,000 as recommended by code enforcement of the City of Lakeland. It's a harsh penalty, but I believe that it's justified.
That's your order? Yes. Thank you.
Case number LCE 23-01022, 520 Forest Lake Drive. Good morning.
Angela Kaiser, Code Enforcement Officer with the City of Lakeland. Case number LCE 23-01022, address is 520 Forest Lake Drive. The owners are listed as Lakeside Hills Estates Association, Inc. The violation of Section 86-3, or -3, for dirt, filth, et cetera, on streets and alleys prohibited. Date of the violation is 3/9/23, to be corrected the same date as this also was cited as irreparable and irreversible damages. The re-inspection's the same date. So this case was originally cited under LCE 23-00259. That was actually opened on January 18th, 2023. It had to be closed and recited due to administrative errors on the case. So that's why the dates are different, but the actual occurrence was from January 18th instead of March 9th. So I just want to clarify that. So the case was cited for irreparable and irreversible damages on a site where a seawall was being installed at a mobile home park at this location. The issue, there was a couple different issues with this. The violation was first noted by the Lakes and Stormwater team when out on the lake, and they noticed the seawall construction, and they noticed some sediment discharging into the lake at the boat ramp location. So when I went out there, I made contact with the contractors on site and discussed with them what was happening, asked them about placement of the sediment, the dirt that they were using for their job and asked them about their BMPs, et cetera, their best management practices to protect the lake. They showed me permitting from the city of Lakeland, and they showed me pictures that they had been taking along the way. So I took pictures of their pictures, and I've included those in the attachments here, and so she'll get to those in a moment. But what happens is, not only did they not follow, so these are some of the contractors' pictures, and this picture in general shows, so what I was told on site was that the contractors had been told by some unknown person with building inspection that they didn't have to notify anybody else. All they had to do was take pictures and keep the pictures of their work and showing their BMPs with their permit to show that they're using BMPs and they're doing things properly. The problem is, when you look at this picture, you can see what those yellow things are. Those are turbidity curtains, and you put those in water and the curtain drops to the bottom of the lake or waterway, and it is supposed to stop the water that gets turbid where the work is being done from discharging into the lake, so that you have a smaller impact to the lake area when work is being done. What you can see in this picture is that those turbidity curtains are failing because you've got muddy, murky, very chocolate milk looking water on both sides of that curtain. And one side should be clear and one, normal lake water, so it should be greener looking, and the other should be the turbid side. So clearly their method failed, and by our city's permits requirements, they are required to do a pre-construction meeting, which means all parties involved in the city of Lakeland that would have anything to do with the lake system, with the seawall, with the engineering department, with building inspection, there would be parties, members from all those departments meet with the contractor on site to discuss exactly what's going to happen, where they have to put their BMPs, that they're going to be monitored on a regular basis by the Lakes and Stormwater team, by code enforcement, by engineering, by building inspection, so that eyes are constantly on that site to make sure that that lake is being protected. In addition, they're required by state, by the Florida Department of Environment, to have a permit, which they did not pull. And because the state of Florida owns lake body water. So they also did not pull that. So because of the discharge, the sediment, what I was told by the people on site working, was that the sediment was supposed to have been dumped further back away from the lake, but the day that it was delivered, they didn't block off go back to that picture. They didn't block off the driveway, which is to the right side of the edge of the building. And so different people from the neighborhood that were coming to this building parked there. And that's where the dirt was supposed to be dumped. And so they didn't stop anybody from parking there, and then they didn't go locate those vehicles and have them moved when the dirt got there. They just dumped it right next to the lake. And find the picture where it shows how close the dirt was to the boat ramp and the edge of the water. Yeah, sand. Okay, right there. So you can see the sand was dumped within a few feet of the edge of the lake, right there on the boat ramp. And so they had a small rain, and it washed some of that sediment into the lake. I'll let Lakes and Stormwater come up again and tell you why that sand going into the lake is considered an illicit discharge and it's unwanted. And I'll let them explain any other environmental impacts that the work that they did can do to the lake. Sandra? Again, this is Sandra Pope from Lakes and Stormwater.
Thank you. So whenever we have releases of this nature, additional sand and sediment into the lake can cause damage to fish gills. Fish gills are designed to breathe clean water, not muddy water, and so it can also smother aquatic insects. It can smother fish eggs, and depending on how far out the extent of that muddy water goes, can cause some adverse impacts to the aquatic wildlife in that area. You're welcome.
gave our request, sorry, or our recommendation. So at this time, the city's asking for a fine of $1,000 for irreparable and irreversible damages, as they cannot be corrected. Again, once the discharge is in the water, it is better left to settle versus having it removed, because that just causes more damage.
Yes, it's Eric McCoy. I'm the general contractor. I also have a marine contractor's license. I own EMC Construction. Good morning. Well, that's one side of the story. So I'm going to explain to you the other side of the story, and I'll show documentation that we did everything by the book with the city building department. The lady here had stated that someone had supposedly told us, and we didn't have a name. We did give her a name. He's an inspector for the job that it was on. His name was Harold something. Harold Jordan. He's a building official. He does all the inspections. Harold Jordan did every single inspection, and in fact, prior to that, we had already done a dock and a seawall in the same development, and there were no BMPs. We put our own BMPs in because the city of Lakeland says that we're required to do that and have an inspection with the city. So we started this particular job on the 9th. I would like to give you a calendar. I'll give her also a calendar so that you can follow it. I've had back.
This is just for Athena?
One for you. Oh, I'm sorry. Can I have the one back? Give her the pretty one with all the colors. You and I got black and white. I thought this would be a good idea for you to look at it. If you look at January 9th, it says Rusty started at Lakeside HOA. This permit was issued. We had the dirt delivered. There were no complications of cars in the way. There was no specifications as to exactly where we were going to put the dirt. The building department was told that it would be put in the parking lot. And the dirt got delivered the 10th and the 11th. And then, ironically, which was really weird, January on the 13th, we got a bad rain. It was a massive rain. And if anybody was in the area on that particular date, they'll remember that rain because it was atrocious. We started doing all of our work. We had already taken pictures that we put the BMPs in. Then we called for our first inspection with the building department. We have to go through the building department. We don't have these meetings and these get-togethers and sharing logics and ideas, and I've been doing this for 26 years as a general contractor in Polk County. Never once I ever had the opportunity of meeting you, anybody else, the lady in the back. We don't have these kind of meetings. The building department tells us what we need to do. Now, we know for a fact that on the 17th, we called for an inspection. The inspection was for a pre-con, what is a pre-con to you?
Construction.
Pre-construction, right. On the pre-con, it says on the inspection note that, inspection here. And this is, and if you want a copy of it, that's fine, I don't have an issue with it. And this is from the city. It says, and this is addressing Harold, this is from the building department. And it says building shoring, the results was approved. It was scheduled on 1/18. It was completed on 1/18. It was inspected by Harold Jordan. And on the notes, it says, please look for turbidity barrier and ground bracing. Ground bracing was part of our inspection for the wall. He came out, he inspected it, looks good, continue on. We have no issues. We put the turbidity barrier in like we're supposed to. Then all hell breaks loose. Somehow or another, Storms and Drains then gets notified. On the next day, and you'll see on the 18th, it says EMC receives a call from Dale Margaret, Chief of Building Inspection, along with Cole Edwards and 4 others. And if you'll see it down there, my secretary's writing 4 other people. It was a shit show, and I'm sorry to use that word. Everybody was bickering on the phone. He said, she said, what did you do? Why didn't you inspect this? Well, you didn't notify me. My secretary was just listening into this. It was terrible, she said. When it was all said and done, on the 18th, after we've already had our inspection, then the inspector, Angela, comes out and then starts, you know, hey, I got a problem with everything that you have going on. On that particular day, and you see in the picture, can you go to the one where she shows the boat ramp? Now, mind you, we've already had this inspected by the city. This is the COL, the City of Lakeland. They inspected everything. They okayed this. This was a mistake. Maybe looking back, maybe we should have put a barrier on the boat ramp. We had no idea that that rain was going to come in January. It was an honest mistake. Did it harm the water? Come on. This is sand. This is sand which you put for all your buildings when you build. This is sand that is approved by the state, FDEP, to put behind your retaining walls, okay? You'll see it. It's not a large amount. Truthfully, it came out to be 20 buckets. So on that day, Angela advised my employee, do not touch this. It is toxic, it is under investigation, and that she was doing a report on it. So my employee reached out to me, told me the problem. I'm like, well, Jesus, if it's toxic, let's get it out of there. Come on. That's not right. You can't leave it in there. It's right there on the edge. Needless to say, she said it was very toxic. I will show you proof that this sand, right there, that bag, I have a receipt that states that it is clean fill. Supply 8 loads of 18 yards, CLM, clean fill dirt, no chemicals. And if you would like a copy of that, I'd be more welcome to give you that here. And that was from a company called Gardner Complete Site out of Auburndale. Okay. So once Angela came in, you know, and these are really important things, and I listen to everybody, the professionals, but sometimes there's some common sense that's just going right out the window. Angela came over, she's doing her job, I totally respect that, but she says there's a problem. In her notes, she said, let me find yours. Violation site, city violation. There we go. In Angela's notes, which you get online,
What's the date of that so that they can pull that up?
1/18/23.
Thank you.
Thank you. She said that Sandra Pope contacted her that there was a problem at the seawall. And it just goes on and on and on and on and on. But at one point she says, there is a permit pulled, which included a pre-construction meeting where the contractor would be told by different inspectors from the COL. What is the COL, ma'am? I know what it is, but I want to make sure.
ahead.
COL, what is COL?
City of Lakeland.
City of Lakeland, okay. By different inspectors. We only work for one group, the building department. We don't have these powwows with all these others. They know that. They don't ever meet the contractors out there. Because I've been building enough docks and seawalls, I've never had a meeting with them before. I do know that the building department, because of this, and we'll talk to Sandra about it, has made some changes because they've realized that they're not communicating together. Left hand doesn't know what the right hand's doing. That can negatively impact the construction. The pre-con meeting was not inquired on until this week at the job. Well, no, the date, we did the pre-inspection, and you'll see it, that, or you have it, that we passed it on the 17th. We did everything that we're supposed to do. On the next page, she makes a comment, and this is pretty important to me. And she says, in the middle, the representative spoke to on site was Rusty Stedham. This is Angela talking. Rusty Stedham is my field supervisor. Rusty's been with me 26 years. This isn't his first rodeo. Rusty Stedham at phone number. His office manager, Candy, which I have Candy here with me, my office manager. He asked that I forward all information to her to get it to the owner. Meaning, Rusty was telling Angela, we need that information. We need to know what to do. What's the problem? We're going to clear it up on that date that Angela came out. I will be doing that today as I ran out of time before the end of the shift yesterday. I also attached pictures. Hey, she ran out of time. I totally understand that. No big deal. When did she contact us? On the calendar, you'll notice that was on the 19th. It said advised violation site inspector. On the 20th, we called her because she hadn't reached out to us because I'm now concerned with the boat ramp. Left message, could not leave message. Saturday, obviously everybody's off. Sunday, everybody's off. The 23rd, we could not leave a message. 24th, could not leave a message. 25th, could not leave a message. We did find out from Angela that she had told my secretary, because I was standing there, that she found out through someone else that her phone was full and couldn't leave any messages. Well, we're doing our due diligence to try to rectify a problem that she's saying that there's a problem with. And, this might be an administrative thing where they need to look at her performance. But our performance is that we're trying to resolve the problem. Continues the dead man's inspections and scheduled. And then we had the inspection again for the second dead man. Finally, on the 27th, which is 1, 2, 3, 4, 5, 6, 7, 8, 9 days later, Angela finally gets a hold of us at the office. And my secretary texts her and says, hey, you need to call me. We got a problem here. In the meantime, I took the initiative back on the 24th. We're getting that sand out of there, all right? We already had the BMPs in place, the second one. So I said, get it out of there. Let's do the right thing. Get it out of there. No, we're not going to go out into the lake. But there was none out in the lake. It was only right. Can you show me the picture of the boat ramp, please? It was only at the boat ramp. Saying it was out there, no, it wasn't. And if it was, show me a picture. That's where it was at. That's cardinal knowledge. It's right there. It's not out at the lake. All right? So finally, Angela gets a hold of us and tells us, you got a problem. And we were like, okay. Well, 2 days later, you can see on the 30th, we're all done with the job. We went through all of our inspections. Now, I'm going to back up a little bit. On the 26th, we had on the Lakeland building, let's see, 18th. All right, another framing inspection. On the 26th, and it says it right here, approved. The inspector, who I've told you the name of, he came out and he told Rusty, that barrier there, get it out of here. You don't need it because you got your aluminum panels in. The barrier does not do anything because now you've got 10-foot panels, aluminum panels, all the way down into the wall, and there's nothing going to get past that aluminum. We didn't because there were some people pretty upset. So we left that barrier in. But the building department, building official says, get it out of there. You don't need it. Bring it over here to the second phase because we were going to the second phase. We left it there. We put more BMPs out for the second phase, went through all the inspections and was approved. All right. This is a case of I'll leave that at the end. I'll talk later. You took it.
It was your contractor's pictures.
Okay, so the date of, okay, so that would have been, that would have been on the 9th.
Can I clarify?
Yeah.
So they scheduled their pre-construction meeting on the 17th, but his notes actually show he started work on the 9th.
Did,
So a pre-construction meeting happens before work starts, to clarify, so that all parties are aware of what's happening. Lakes and Stormwater had no notice that this work was being done, and they're the ones held accountable by the state through permitting for what happens to the lakes. So anytime work is done on or around the lakes, anytime, they have to be notified. And that's part of the permitting process, and that's part of the pre-construction process. So for them to have scheduled that, because they schedule it, for them to have scheduled it when the work was almost completed, that's aside, like, there was no point to even call for one at that point. But his permitting required it, so he went ahead and scheduled it on the 17th. So for clarification also, I was never told Harold Jordan. Your Rusty did not know the name. I asked him specifically, and I was never told Rusty, or I was never told Harold.
What you could
So-
have done is looked it up on the building department and see who signed off on it. You work there together, don't you?
We don't work in the same department, we don't work in the same building.
Well, this is where the problem is, the left hand and the right hand. You guys don't communicate with one another. You don't deal with the storms, does not deal with the building department. And that's obvious here. There is no get together and, hey, let's talk about this and let's get everybody together. No, it's not. It's just the building department. That's all it is. So if she wanted to know who the inspector was, she could have just looked it up. And she has easy to that software. It's not my problem. That's hers. She could have looked it up.
Is he the only inspector that ever came out? Because normally,
Yes.
there will be multiple inspectors
Yeah, we
per
were very
permit.
fortunate. He was the one all the way through.
Okay.
Yeah.
See, I wasn't aware of that
And
either.
he was also the same one that did the other jobs that we had no inspections on.
Okay.
And there was other jobs in that development 2 days, 3 days prior to that. And we took pictures of that too to show that we do the barriers.
This area here in the picture, is that right next to the ramp?
No, the ramp is way at the very end. This is where, and to give you an idea, so Angela here talked about the turbidity barrier.
Turbidity barrier.
Turbidity barrier. She's completely incorrect. Okay, I'm sorry. The turbidity barrier does not have a screen. It is a orange thing that you see, and it basically stops all the stuff that comes to the top, which is just sand because we're jetting out. We're not using any equipment to put these panels in. We're actually using, if you want to call it a water hose, it's just on a jet pump. There's no screen. I would think she would know that if she's come out to inspect these, but there's no screen. All there is weights that hold it down. That's it. So she's incorrect on that too.
Let Sandra Pope go over that. She's the expert in that field.
Just have one more question. So in this picture, were you already getting out for,
We're jetting out.
So-
So that's where you see all the turbulence. I'm sorry.
okay. Nope, that was mine.
Yeah, that's where you see all the turbulence. It just comes to the top and then it settles right back down. It's just sand. We're blowing out sand that's there already. We're not bringing in any other chemical at this point in time because we don't do that yet. We're just blowing out sand. That's just sand. So all that sand is going to do nothing to the waterway. In my opinion, professional opinion.
When turbidity curtains are installed properly, they're very effective at containing that turbid water. And had the inspection by the Lakes and Stormwater team been called at an appropriate time, we could have verified that that curtain had been installed properly. Second point I wanted to bring up was when you stated that we would not allow you to pull that sand out of the water that was in the lake near the boat ramp. So at the point of that request, we had to determine whether or not you had pulled state level permits because that lake bottom is owned by the state of Florida. It's sovereign submerged land. And so without having state level permitting in place, we would not be able to give you authorization to remove anything that might affect the lake bottom. So at the point of that request, I did research and determined that the appropriate Florida Department of Environmental Protection permit had not been obtained, and so they are now also involved in getting this site into compliance. I have the letter here dated April 10th, 2023, from the Department of Environmental Protection stating that they are requiring permitting or to remove the structure and restore the shoreline. So that gives an explanation as to why I could not give that authorization because the state level permit had not been pulled for this project.
So to answer your question on that, here's another great communication. And I can't speak for the other counties, but in this county, and everybody looks at the county, They are kind of the gurus, they're the breaking edge, they have all the information, and I know for a fact that the city of Lakeland contacts the county about questioning about different things. The county requires you to have an FDEP permit. You have to, no ands, ifs, or buts. And there's a couple municipalities that require it. Other municipalities do not require it. We have reached out to the city of Lakeland, to the building department, and asked, do you want an FDP report? It is so easy. Let me explain to you how it's done. We pull up the copy of where the wall is. We put it on their website. They show it on their website. And we press a button that we're putting a wall in and that we're not going to be taking on any land. It is instantly issued, instantly, literally in 30 seconds, and I kid you not. And we've been pulling permits with FDP for 25 years. So when this happens, you got to wonder, why isn't the city, let's take some responsibility here. Why isn't the city, why isn't the Storms asking the building department, hey, don't issue any permits for docks or retaining walls until an FDP permit is approved. It's done electronically. It's an easy thing to do. It doesn't cost money. Do you think that Storms is working together with the building department? Absolutely not. That's the reason why we did not get it, because the building department did not want us to do it. Now, it's going to cost me about $5,000 to have a survey of the wall, and that's all FDEP wants. They just want a survey of where the wall is in relation. And I've already been on a conference call with a supervisor, and it's going to cost me about $5,000 just to show where the wall is at. We could have easily said, get it approved. I would say to you, when we're done with this meeting, you need to go back to the building department and put your foot down. If you've been working at this department long enough, you will agree with me that if FDP is required, then have it required prior to the permit being issued. It's a very simple process. We make application, City of Lakeland will say, nope, we want an FDP approval. Oh, we faxed it over, it's done. No issues. But now, because they didn't do their due diligence in making sure that there's FDP, now I'm jumping through some hoops to have a survey done of the wall at a tune of $5,000, because you can't get a survey company to do it. You have to get an environmentally survey company called Chastain and Skillman. Chastain and Skillman. We've used them in the past for other environmental things where we got to get FDP approvals for, 5,000-foot docks that go over water that's controlled by the state. So we're very familiar with this. We know what we're doing. I hate to say this, but I'm going to tell you right now, her office and the building department do not communicate, and it's obvious. I mean, it's real. I'm trying to show all the things that go on there. Go ahead.
So it is part of your building permit to acquire all permits that are required relating to your project.
Okay, so my question to you is that how come the permit was issued if it's required?
As a contractor, the responsibility falls on the contractor doing the work to secure all necessary permits, state, local, whatever is
I will
needed.
professionally disagree with you. It's the building department to tell us what they want. That's the way it is. If you go to the county right now and you want a new dock at your house, guess what? FDP approval is the first thing. The reason why the county did it is to take the liability off the county. It was a really smooth move because now the county doesn't get in trouble if the dock wasn't placed right, because FDP comes out and inspects it after about 6 months. But I will tell you that it's not my responsibility as a contractor. It's your office and the building department to communicate and say, hey, I want these things done before that permit gets issued. It's kind of like dangling the carrot. You want the carrot, jump through the hoops. We don't have an issue. Just tell us how to play the rules. It's very easy.
As a licensed contractor by the state of Florida, I expect that part of your licensing requires you to know what permits are related to your projects.
I do. And when we ask you, do you want it? And your department says no, I go by what your department says, not your department, the building department. So in the future, I've already told my
Yeah,
secretary.
regardless of the permitting, I'm just going to look at the facts on whether or not there was a violation under the code that was cited. I do have a question regarding this area here.
Okay.
In, regardless of the, area on the boat ramp. If the area in the boat ramp, there was never dirt there or sand there, and they were jetting out, to put in the
Panels.
panels, what violation would this be here?
Okay, so this one is the, hang on a second.
It be what's cited here, what they've been, the code that they've been cited with?
We,
Well, she's asking on that picture, so I think you need to address that one first. Okay.
Also, Code Enforcement Manager Sonny Marshall, we did call the building division, and the building official, Dale Marquardt, is here to clarify any communication between the building division and Lakes and Stormwater. So he's also here.
And you'll also see that with the name that she said that Dale was there, he is in that little block on January 18th, that he was all part of that meeting.
so if you read that ordinance, it states it shall be unlawful for any person to throw, spill, place, deposit, or leave, or cause to be thrown, spilled, placed, deposited, or left, or to permit any servant, agent, or employees to throw, spill, place, deposit in or upon any street, highway, alley, sidewalk, park, or other public place in the city, any dirt, and lakes are public places, dirt, sweepings, filth, shells, garbage, vegetables, dead carcasses, sewage, slops, excrement, compost, stable manure, ashes, soot, tin cans, rags, sorry, my eyes are not as good as they used to be, waste paper, leaves, what does that say? Oh, slops, excrement, compost, stable manure, ashes, soot, oh, I've already read that part. Brush, thank you. Weeds, grass, straw, hay. Anyways, dirt is listed in there. And it continues to describe things, litter, loose combustible materials, materials subject that can be carried by the wind, or unwholesome, noisome, or putrescible matter of any kind.
May I ask something? When speaking to her, because I think I know the answer, didn't you tell us that we had 2 violations, and you were one for the boat ramp and one for that pitcher, and that you were just lumping it together and it was up to $1,000, correct?
So it's 2 different types of discharge,
Okay.
but it's the same discharge. So it's still the same damage.
Okay,
So instead of citing 2 cases and finding you twice,
okay.
which is not fair to you, you put it together in one case.
So some of that 1,000 is based on 2 problems, correct?
It's based on damage that was caused to the lake in
So-
2 different areas, 2 different ways.
Okay, so 2 different ways. So one could be 500 and the other one could be 500, the other one could be 700, one could be 300?
We don't do it. In a fairness to you, we don't do it that way. We do it one time, one fine. I mean, I don't break it down that way.
I would say that the $1,000, they're coming up with the 2 different violations, and that's what she told us, is that there were 2 violations, and that's why it's up to $1,000. So if it would have been 1 violation, would have been less?
No, it's still one violation, because it's all the same violations, all the same ordinance.
I'm just going by what you
So
told us.
it's 2 different discharges,
Okay, 2 charges, but 1 violation?
correct?
Okay. Clarification. Thank you.
So at this time, I'm going to call Dale Marquardt up here. He is the building official. So he's in charge of all of building inspection, and he can clarify any statements made in reference to how they work these permits, et cetera.
Alex, can you swear Dale in?
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the whole truth, nothing but the truth, and so help you God?
So I believe that there was some questions or discrepancy on the respondent's part on what the expectations and requirements were per the building division versus lakes and storm water. And I asked Dale to come over to clarify because lakes and storm water's requirements are different than what building inspection inspects for. And if you could, Dale, explain that when it comes to the turbidity barrier in the seawall.
Yeah, usually in a permit case, or in a permit, the inspections usually go with it's called a pre-con, a pre-construction that Lakes and Storms goes out and verifies that there is a barrier set up where the construction is going to be done. Then once that's placed, they approve it, and then the next step would be for them to put up the seawall and construct it to a rough state. So then we can come out and look at it at the rough state where the anchor points go into the ground and whatnot. And then, per the drawings that were supplied by the permit and their engineered drawings. And then after that, they're able to fill in the dirt and everything to cover up everything for the seawall, and then we do a final inspection. Then once we do that final, Lakes and Storms comes out and makes sure that they remove the turbidity barrier, and no settlement went into the lake, and after that, the final, and then once that's all done, I can't even talk, the permit has been final.
They're looking out, inspecting the permit, they're not looking for any violations, code violations.
No, we don't look for them. I mean, if we see them and they're blatant, then we do call up code enforcement, and then they, run it through their process.
So just to get a little insight on Harold's inspection, it was done on the 18th, January 18th, 2023 at 9:03 p.m. Angie responded later on that afternoon at 4:15. So I'm not sure if between then, was it?
It was before then, 4:15 was when my notes were.
Okay, so that's when her notes were entered in. Do you know what time you were called out? Okay. And that's all I have.
The pre-con for Lakes and Storms is to verify that before they construct, that the barrier is put up and put in place, so there is no cross-contamination.
So that, just to clarify, so that should be done before the work is started.
Yes.
A question. Hi, Dale. I don't think we've ever met. I know we've talked on the phone
have.
maybe a couple times.
Yep.
Okay. So there's no personal thing here. Are you aware that, are you aware of any kind of violations, anything, any slaps on the wrist, just anything in wrongdoing from my company or me as a general contractor or as a marine contractor?
No, actually, he's been real good
Thank you.
on just about every case. I mean, there's time to time where he might miss an inspection here or there, but he does call up and we'll go out and verify everything.
So thank you very much. I appreciate that.
No problem.
Are you aware that Harold had said that, or were you aware that Harold, when he was coming out to do the first inspection, where I had wrote and, or where it's typed in, that it says, please look for turbidity barrier and ground bracing? And that would be this thing here. And
Is that on the 17th?
this is on the 18th. We're all family. This is. And this is the first inspection.
Okay.
All right. Are you aware that it's in there that Harold's supposed to go out there and look at it?
All right, go ahead. Normally, Cole Edwards goes out from Lakes and Storm to look at that.
All right, all right. So on that particular day, though, Harold was the one that was assigned it, and it's,
He was assigned
yes,
the Tribune barrier, the
yeah,
pre-con.
yeah, right here. Please look for turbidity barrier and ground bracing. This is when we had our first one.
But the inspection that Harold was assigned to was called the building shoring.
Okay,
So that is not the,
but yet
he
it's,
can mention that, but he can't, he's not
It looks like,
License to really approve that, so the Lakes and Storm pre-con.
in
like
looking at
old
this,
Edwards.
I don't think that's his typing. That's coming from the building department, because it says, please look for, who's typing that in? Someone in the building department?
It's probably, he'll tell you if you bring
Okay.
an inspection. That would be
All right, thank you.
the shoring.
Sorry. I just can't bend over. Sorry. Thank you. All right.
Tammy, put that note in.
Tammy, and she, all right, sorry.
Tammy Vivi, my permanent tech coordinator, put that
Okay.
note in.
So permit tech coordinator, Your Honor, we're working with them. We're saying, hey, we need the inspections. Let me ask you one last thing. So you're aware that we have done other docks and walls in that development just prior to that? A couple days?
I mean,
And then
you've
like
done them
6 months?
for, a couple of years
Yeah,
now.
yeah.
It's
Are you
not-
aware of any time that we've ever had a inspection by the storms and drains prior to that? Are you aware of any, and you might
I
say
would have
no.
to investigate it. I
Okay,
can't give you
all
a
right.
definitive answer on that.
I will say that we've never, ever had a get-together, or whatever you want to call it, a pre-thing, because when we've been told by the techs, and they're the techs are the ones that we got to apply for, not apply, we have to make inspections, take pictures of the verbidity barrier before you start. Okay, put it in the packet. We do. We put it in the packet.
I know why Tammy put that note in was to, when Harold went out there, Lakes and Storms at that time hadn't been out there, as far as I know.
Okay?
Oh, yeah, you were out the day before. We've been running across other violators, we'll say, that seem to always miss that. I mean, Cole can vouch for that. So Tammy's been putting that in as a note for our inspector to make sure that it's there before anything. If not, we're gonna have to call code enforcement.
So the work
So it's a
was,
general note that's
the
always
work
put
was
on.
started on the 9th, is that correct?
Yes, ma'am, on the calendar, yes, on the 9th.
And there was a the pre-construction inspection on the 17th.
No, so they don't, this is what I'm trying to explain. They don't ask for a pre-con inspection. They tell us, take pictures of it. On your first inspection, we will inspect the turbidity barrier. And we've always told everybody that. And in fact, if I may read from Angela, that there's a point where Angela is having a conversation with my office manager, and it's from Angela, that my office manager is saying, look, we don't ever do it that way. We've never done it that way. And she's like, no, that's not right. Okay, wait a minute. These dumped into Lake Gibson. I was able to, representative. There is a, shame me for, I don't know where it is, but I know it's in there, that we told her, well, look, we don't have that inspection. No one asked for it. We just have the first inspection. That's when they look at the turbidity barrier and they look at the picture.
I understand. So
Thank
on
you.
the 9th, when the work was started and you began to jet out to put in the wall, were
Yes, ma'am.
you aware that by jetting out to put in the wall, that disrupting the sand on the bottom would be a code enforcement violation?
No, because we already had the turbidity barrier in.
Right, but as you said, it doesn't have a sheet down that goes down to protect, to keep the sand or whatever's on the bottom that's being jetted out from going into the rest of the lake.
So what is your question? Am I aware of what?
That there should have been a barrier so that when you're jetting out, it wouldn't disrupt and push sand into the
This
lake.
turbidity barrier is approved for the entire United States, and it's very costly. Each link is about $800, and each link is about 30 feet. And, we've got $10,000 in verbidity barriers. These are the verbidity barriers that we have ordered. We've had them for, I'd say probably 4 years, because some municipalities do want the verbidity barrier. We put the verbidity barrier up. Now, there are other verbidity barriers based on, they have a screen, that sort of thing. And I don't think that there's anything that says, I'd like to see it, if there's anything that says from storms and drain, what type of verbidity barrier? And they'll have to specify it by what is made by the state. And we're not.
reading the section of the code that is cited as a violation, it appears that if you're jetting out anything and disrupting the sand on the bottom of the lake, that would be a violation, and that a barrier needs to be in place. And I
was.
understand
And it
that
was.
it may be a barrier that would prevent the sand from going through.
I make a clarification here.
It won't do-
Okay.
It won't, do-
So the turbidity barrier that he had, it's actually a full turbidity barrier. The curtain that I'm referring to is that section that drops down with the weights at the bottom. So that acts, that's what I'm referring to as a curtain. So it acts as a curtain to separate the water sections. And, you know, Cole Edwards is here and he can clarify stuff, you know, if I'm saying this wrong, but the weights are supposed to take it to the bottom. Well, in this area where they're working, there was all kinds of lily pads, all kinds of vegetation, things like that. And sometimes those weights won't drop down through that vegetation to the bottom. So there's still gaps where the turbid water
This
can go
does
up.
curtain is-
So yes, so this is the proper turbidity barrier. It just may not have been installed properly. And so, you know, Cole can confirm this, but sometimes if they see this kind of thing happening, they'll ask for an extra one to be put further out because there's an understanding that maybe there's an issue here that they can't work around. So we'll put another one out. Am I correct, Cole? And to clarify, this is Cole Edwards. This is Cole Edwards from Lakes and Stormwater. He was the one who was supposed to be notified before the construction because it's his job with the city to monitor any activities on the lake while they're happening to make sure that this kind of thing doesn't happen. Cole, if you would like to add anything else or to clarify what I've said.
Okay. Yeah, kind of like what she
Identify
said.
yourself, please.
Oh, yeah. Cole Edwards from City of Lake and Lake Stormwater, engineer.
Were you sworn in?
Yeah, I was in here.
Okay.
Yeah, thank you. Yeah, the curtain basically acts as she specified. If it hangs all the way down, it basically just prevents the water column from shifting anymore, kind of stuff and all. That is something that would have been discussed on the pre-con part of it. It would say if it wasn't looking like it was sinking down or if the plants ran away, we could have allowed to either, you know, kick it out farther or the second row is always a thing, but we understand that costs a lot of money too. So a lot of time we just try to see if we can, how far we can move it out to get away from everything. The pre-con's also supposed to be for making sure that, you know, any native vegetation's not being damaged. It basically is just to address all the potential problems that might come up so that doesn't happen, I guess. And
Anything else you would like to add? Okay, and to clarify, because you were in the middle of saying, and then you got cut off, that Harold Jordan, that you as building inspectors are not the ones that are licensed to do the approvals on the lakes and stormwater side of the protection stuff.
Correct. We do look at,
Come up,
Please speak here.
correct. We do look at other tribune barriers, like on job sites and stuff, but when anything that goes into the water or the vegetation, Lakes and Storms handles it all.
Thank you.
I think you have the gist. I think bottom line is that there needs to be a lot more communication between those two organizations. And then obviously they tell me what they want to do. As I said, we've never had a powwow. We've never done this in 25 years. It just has never happened. They've never enforced it. You know, they leave it up to the building department and expect the building department to carry it. I'm sure that they have made some serious changes, and we'll find out because we have another job eventually coming up that's in the city on Lake Parker. We'll see how they operate on that one. We know what we need to do, but unfortunately, we got to follow the rules, and we're told the rules by our building department. I ask that you don't find anything. There was nothing in malice. There was nothing in trying to make something wrong. There was nothing in trying to skirt around, you know, shady work. The building official, I mean, that's the top dog right there. He decides whether or not I get permits, and it's my well-being, and I have 14 employees to handle with. We don't try to break the rules, but we can only go by the rules that we're told. And we look at the building department and tell us, hey, what's next? And if Dale hasn't picked up on this, I strongly suggest that Dale says, hey, everybody's got to do FDEP before you even bring the paperwork to my building department. No ands, ifs, or buts. The county does it that way, and a lot of municipalities, and Dale knows that. It's the right thing to do. And it takes us 30 seconds and we get the approval. No issues whatsoever. Now I'm going to spend $5,000 and it's a headache trying to get an environmental wall put out there. So I think you need to take that in consideration too. But there was no malice. There's trying not to skirt the system, not trying to beat it. We're trying to do honest, respectable American work, bottom line.
Just to clarify to you for future, the pre-construction meeting, which is exactly what the pre-con is meant to be done ahead of time, and that is what triggers the notification to all the other departments that you're doing the work you're doing. So that's how we communicate, is via this system, because the city doesn't house us all in the same buildings, so we don't communicate that way. We communicate through the different the permits and track it, the different cases and track it. That's how we communicate. So if you don't notify us of that necessary pre-construction meeting, we're not notified.
My question to you, I
Sure.
understand.
Okay.
My question to you is that doesn't Storms and Drain have to sign off on this building permit before it's issued by the building department? Yep, I know the answer, but I.
So I'm
they
told-
do.
Thank you.
Okay, so Storms and Drains already knows that there's a permit being issued. Storms and Drains then should use common sense, send an email to us. Hey, we need to have a get-together. I'm all for that if we're going to get together. If I'm going to meet with, Mr. Cole, whoever, I don't have an issue with that. But you got to put us in the loop here. You're not. You're keeping us out of
That's
the.
what the permit's for. That's what the pre-construction meeting that you
I know, I'm talking
put
about
in.
notification. Once you sign off that there's been a permit issued, you need to send an email, you need to send something certified that says, hey, we know you have a permit, and prior to start, we need to have a powwow. I'm all for that. That's an easy thing, isn't it? I would think. And maybe we can ask Storms and Drains. It's a simple thing. Just send out an email. You signed off on the permit, all right, let's do the right thing. I'm ready for it. Let's do the right thing. But send an email, hey, before you start, we need to have a get-together. No problem. Okay,
I've
thank
heard
you.
all of the evidence. Does anyone have anything else? Okay. So I'm going to find that there was a violation, because based on the pictures and when you started the work, it appears that the barrier did not work in this instance. Oh, sorry. There was a violation. When you started the work on the 9th, from the pictures and evidence, it shows that the barrier didn't work, and at that time, something should have been done. As well as the dirt that was on the boat ramp. It's obvious that it did make it into the water, which is a clear violation, and like you even admitted that maybe you should have put some type of barrier by the sand. But I will find the fine to be at $500 instead of $1,000.
Thank you. It's not the money, it's the principle of this. And I hope we all learn.
I understand how.
Yeah, it's tough. Thank you.
Thank you so much.
Page 23, case number LCE 2301663, 329 Doris Drive. Yes.
Darren Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-01663. The address is 329 Doris Drive. The owner is Frank Vecht. The violation is ordinance 3947, Chapter 3, Section 307.4, care of premises, open storage and junk. The date of the violation was April 14th of 2023. It was to be corrected by April 21st of 2023. The reinspection occurred on April 24th of 2023. Photos were taken on June 1st of 2023, and it showed that the violation still existed. The city recommends that the property come into compliance by June 18th of 2023, or a $50 per day fine may be imposed until compliance is met.
The respondent, if you'll state your name for the record.
Roland Vike, I'm his brother, he's the tenant, he lives there, but we just needed to know, we're not getting these, when you guys are getting the violations out to us, they're not coming to us directly because we're the ones that are supposed to take care of it. It's going to the trust, and they're not getting us. I mean, one time there was a violation, and I was told that on the next day was the 30th day of taking care of it. So we stood there till 2 in the morning and got it taken care of. Then apparently after that, there was another violation of the same garage. And that was something we got noticed. We got noticed late on that too. But I would like to know exactly what we're not and allowed to have on the garage, like a refrigerator. Is that something that's allowed? What are we supposed to remove to be in, good graces with you guys?
Appliances are not allowed in the carport.
Okay.
Tools, equipment, there was air compressor, things like that, power washers, but that cannot be stored in the carport.
That's because there's no garage door that you can shut it, obviously.
Right, it's not a fully
Okay.
enclosed garage, correct.
Okay, so basically nothing other than a car parked in there.
Basic, you
Okay.
can have it like a barbecue, a grill or something
grill,
like that,
okay.
because that's designed to be outside.
Right.
Refrigerators are not designed to be outside. That's what the expectation is.
So what we know for sure, because we weren't told exactly, there's nothing on the papers that we get that says specifically what not to have on there, at least nothing that I've seen, so, but as long as we know, then we know.
Yes, sir.
And we have until the 18th is to get
Yes, sir.
this. So right now, it's just the refrigerator that needs to come off of there and,
Refrigerator, and then last on the inspection on the first.
okay,
You can see the.
cabinet.
Looks like there's is that a air compressor or
Yeah,
power
just
washer?
just a cabinet for outside.
Yeah.
Okay, and the tire changer, that was removed already, that was put, that was removed, so, but those two things there is what will get us taken care of
Yes, sir.
as far, okay, okay.
Darren can schedule a time to meet you at the property, and he can give you his business card
Okay.
and schedule that.
Yeah, we just needed to know, that was all, because we're the ones doing the work as far as what the cleaning's gonna be, and as long as we know what, then that makes it a lot easier on us,
Yes, sir.
so, okay.
I have a question. Where are the violations being sent to, the notices?
The address, that I do
Can
not
look that
know.
up. Being sent to the bank, is the property in probate?
It still is, yes.
Okay. So the notice was sent to Citizens Bank and Trust.
That was just when they got the notice, they didn't give it to us immediately, like to me, it should have been within 24 hours, that we should have been notified of it. And I think
The
the one
property-
time it was almost 30, pardon me?
I'm sorry. I
One
didn't
day
look
was
it up.
almost like 30 days. It was right until the last day. And then the second violation was not immediately given to us either. So, but I mean, I know that's not your fault, but just explaining, why maybe something didn't get done when it should have been done, I guess.
Property was posted also, the notice.
And you, June 18th is enough time for you to get this? Okay. Okay, great. So I'm going to find that the suggestion of the hearing officer for compliance by June 18th, and if there's not compliance by that date, then there will be a fine of $50 per day after that.
And we'll reach out once it's done to set up with you.
Give you my card when we're
Okay,
Yes.
okay.
Thank you very much.
All right, thank you.
Page 26, case number PER 23-01011, 1136 Palace Place.
Joey Brownlow, Code Enforcement Officer with the City of Lakeland. I'm not sure if I need to present this because they chose to do a summary before testifying.
You could present it as the summary and the
Okay.
recommendation that is made on the summary disposition.
Okay. Joey Brownlow, Code Enforcement Officer for the City of Lakeland. Case number PER 01011. Address is 1136 Palace Place. Violation is owner is Ashlyn and Dennis Wilson. Violation is permit required. Date of violation 3/8 of 2023. The respondents have chose to do a summary, so the city is going to recommend that we accept the summary disposition for 30 days to comply. Oh, or a fine of $30 per day may be imposed and run until compliance is met.
That 30-day compliance date is July 8th, 2023.
I'll accept the recommendation for 30 days to comply and a $30 per day fine thereafter.
While I'm here, I have another one on the same page, page number 26. It's going to be PER 23-01142. Joey Brownlow, Code Enforcement Officer for the City of Lakeland. Case number PER 23-01142. Address is 412 West Patterson Street. Owner is Emily Claire Sack. Violation is permit required. Date of violation 3/16 of 2023 to be corrected by 4/15 of 2023. Reinspection on 4/17 of 2023 and photos on June 1st show that the violation still exists. At this time, the city is going to recommend compliance by July 8th of 2023, or a fine of $50 per day may be imposed and run until compliance is met. And I have been in contact with the owner's brother. They know what they need to do to come into compliance.
Accept the recommendation.
And then I have one more on page 20. It's going to be 412 West Patterson Street, same address as the last one. Joey Brownlow, Code Enforcement Officer for the City of Lakeland. Case number LCE 23-01139. Address is 412 West Patterson Street. Owner is Emily Claire Sack. Violation is ordinance 5425, section 11.6.1. Certificate of review required. The date of violation is 3/16 of 2023 to be corrected by 3/26 of 2023. Reinspection on 4/6 of 2023 and photos on 6/1 of 2023 show the violation still exists. At this time, the city would recommend compliance by June 18th of 2023, or a $50 per day fine may be imposed and run until compliance is met.
So is this in relation to the other violation
Ma'am,
as
the
well?
other one was for a permit, and this one is for historical review because it's in historic district and they did not apply for a historic review certificate.
And they also, have you spoken with this?
Same, it's the brother I've spoken to. I have not spoken to the homeowner, and they're aware of. The permit process would include the certificate of review, so it would just be included.
The date for the last one was July.
Yeah, so that one is a permit case, is 30 days. The historical review is 10 days.
Okay. I'm going to suggest compliance by the same date, the July 8th date, if that, you're saying they happen at the same time?
So they should have applied for a permit, and it would have covered the historic review. Our historic review re-inspections are on 10-day increments, and
Okay.
permits are on 30 days. Historical happens faster than permits if you're just doing historical, but that's fine, whatever your judgment is.
It's okay, I'll accept the recommendation of compliance by June 18th, 2023, or a $50 per day fine thereafter.
Thank you.
Page 2, case number LCE 22-07427, 4740 Puritan Lane.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 22-07427. Again, the address is 4740 Puritan Lane. Owners are Darley Bennett. Violations of Ordinance 3947, Chapter 3, Section 305, and other listed in the agenda. Date of the violation was October the 28th of 2022, to be corrected by December 27th of 2022. Reinspection on February 27th of 2023, and photos taken as recent as June 1st of 2023 show that a violation still exists. At this time, the city recommends the property come into compliance by August the 17th of 2023, or a $50 per day fine be imposed and run until compliance is met.
I'll accept the recommendation by August 17th of 2023 and a $50 per day fine thereafter.
7th of 2023.
For LCE 22-07750, 308 Hawick Lane.
Christy Kroll, Code Enforcement Officer for the City of Lakeland. The case number is LCE 22-07750, and the address is 308 Hawick Lane. The owners are Royce McDonald and Deborah Miller. The city recommends this case be continued to the August 22nd, 2023 Code Board hearing.
I'm sorry, August
22nd.
22nd. Page 2, case number LCE 22-07948, 1036 North Marion Ave.
Alex Gomez, City of Lakeland Code Enforcement. Case numbers LCE 22-07948. The address is 1036 North Marion Avenue. The owner's Discount Zone, Inc. Violation ordinance 3947, Chapter 3, and is listed in the agenda. The date of violation was 11/23 of 2022, to be corrected by 1/22 of 2023. A reinspection was completed on 4/24 of 2023, and photos were obtained June 2nd, 2023. The city recommends that the property come into compliance by August 7th, 2023, or a fine of $50 a day be imposed and run until compliance is met.
The recommendation, August 7th, 2023, or a $50 per day fine thereafter. Page 3, case number LCE 22-08301, 1512 Martin L. King Jr. Ave.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 22-08301 for the address of 1512 Martin L. King Jr. Ave. Owners are the estate of Denmark Aaron Jr. Violations of Ordinance 3947, Chapter 3, Section 305.3.2, roofs, portions, and additions. Date of the violation was December the 9th of 2022, to be corrected by April the 8th of 2023. Reinspection on April the 10th of 2023, and photos taken as recent as June the 1st of 2023 show that the violation does still remain. At this time, the city recommends the property come into compliance by August the 7th of 2023, or a fine of $50 per day be imposed and run until compliance is met. I've actually met with the owner, the representative of the estate, and she said it will be in compliance before the deadline.
I'll accept the compliance by August 7th, 2023, or a $50 per day fine thereafter. Page 3, case number LCE 22-08314, 702 West 14th Street.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 22-08314 for the address of 702 West 14th Street. The owners are Rental Home Holdings, LLC. Violations of Ordinance 3947, Chapter 3, Sections 302, and other listed in the agenda. Date of the violation was December the 16th of 2022, to be corrected by February the 14th of 2023. Reinspection by April the 17th, 2023, and photos taken as recent as June 1st, 2023 show that the violation still remains. At this time, the city recommends compliance by August the 7th of 2023, or a fine of $50 per day be imposed and run until compliance is met.
7th, 2023, with a $50 per day fine thereafter. Page 5, case number LCE 22-08420, 408 Pasadena Circle North.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 22-08420 for the address of 408 Pasadena Circle North. Violations of Ordinance 3947, Chapter 3, Section 302, and others listed in the agenda. Date of the violation was December the 29th, 2022, to be corrected by February 27th of 2023. Reinspection on February 28th of 2023, and photos as recent as June the 1st of 2023 show that the violation still remains. At this time, the city recommends the property come into compliance by August the 7th of 2023, or a fine of $50 per day be imposed and run until compliance is met. I have met with the owner, and they're almost done with the completion, and it will be done in time.
I'll accept the recommendation. August 7th, 2023, and thereafter. Page 5, case number LCE 23-00030, 1220 West Pedersen Street.
Alex Gomez, City of Lake and Code Enforcement, presenting for Daniel Sheets, who's out today. Case number is LCE 23-00030. The address is 1220 West Patterson Street. The owner is a W.J. Jones Ministry Incorporated. The violations ordinance 3947, Chapter 3, as listed in the agenda. The date of violation is 1/4/2023, to be corrected by 3/5 of 2023. A reinspection was completed on 3/6 of 2023. And pictures were obtained by Daniel Sheets on 6/1 of 2023. The city recommends the property come into compliance by August 7th, 2023, or a fine of $50 a day be imposed and run until compliance is met. I do not. He was out sick, so I have not had any contact with Officer Sheets.
I'll accept the recommendation of compliance by August 7th, 2023, or a $50 per day fine thereafter. Page 6, case number LCE 23-00190, 1018 Madison Avenue.
Alex Gomez, City of Lake and Code Enforcement. Case numbers LCE 23-00190. The address is 1018 Madison Avenue. The owners are Lorstein King and Russell L. King. Violations ordinance 4134, Section 1, derelict vehicle. The city's requesting that this be continued to the August 10th, 2023 hearing officer.
Case number LCE 23-00306, 214 Rhea Circle.
Darren Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-00306. The address is 214 Reyes Circle. The owner of the property is Zalea Equipment and Supply, LLC. The violation is ordinance 3947, Chapter 3, Section 305.14, protective treatment of windows. The date of the violation was January 23rd of 2023. It was to be corrected by March 24th of 2023. The reinspection occurred on April 27th of 2023. Photos taken on June 1st of 2023 show the violation still exists. The property recommends that the come into compliance by August 7th of 2023, or a $50 per day fine may be imposed until compliance is met. I have had no contact with this property owner, but as you can see, they still have one window that has not been repaired and fixed, and that's the current violation.
The recommendation for compliance by August 7th, 2023, or a $50 per day fine thereafter. Page 7, case number LCE 23-00364, 821 Augusta Street.
Alex Gomez, City of Lake and Code Enforcement. Case numbers LCE 23-00364. The address is 821 Augusta Street. The owners are SP Abram, LLC. Violations ordinance 3947, Chapter 3, and is listed in the agenda. Date of violation was 2/7 of 2023, to be corrected by 4/8 of 2023, and a reinspection completed on 4/2023 showed it was still in violation. I got photos on 6/1/2023 of the exterior because they have not let me in since that day, and I've not have contact with the owner at all since I've sent the violation notice. So the city's recommendation is that the property come into compliance by August 7th of 2023,
I'm sorry, August 7th, 2023, or a fine of $50 a day be imposed and run until compliance is met.
Recommendation, 7th, 2023, or a $50 per day fine thereafter. Page 8, case number LCE 23-00540, 1610 East Gary Road.
Daniel Povey, Code Enforcement Officer for the City of Lakeland. Case number LCE 23-00540. Address is 1610 East Gary Road. Owners are Keith and Karen Robinson. For violations of ordinance 3947, Chapter 3, care of premises, overgrowth, open storage, and junk. Date of the violation was 2/10/2023, to be corrected by 2/20/2023, re-inspected on March 1st, 2023, and and photos were taken on 6/2/2023, show that the violation still remains. At this time, the city recommends compliance by June 18th, 2023, or a $50 per day fine be imposed and run until in compliance.
Contact with the
Yes, I have. I believe they're working on it. There was a large tree that had fallen in the back. A good majority of it was removed, but there still remains to be a lot of overgrowth in the back.
What is the next, the compliance date, if I can push it out past June 18th? I don't know what the, July 8th, okay. I'm going to fine for compliance by July 8th of 2023 and a $50 per day fine thereafter. Page 9, case number LCE 23-00580, 520 Laurel Lane.
Christy Kroll, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00580, and the address is 520 Laurel Lane. The owners are Chantel K. Harubes and Michael E. Harubes. The violation is Ordinance 5425, Section 5.17.3.5, Parking and Storage on Residential Property Regulated. The date of the violation is February 14th of 2023, to be corrected by February 24th of 2023, and reinspection was on February 28th of 2023. Photos were taken on June 1st of 2023, showing the violation still exists. The city recommends that the property come into compliance by June 18th of 2023, or a $50 day fine may be imposed and run until compliance is met. And I have not had contact with owners on this property, and I looked through the case notes of the previous officer that was in charge of the case and did not see any contact there either.
Any to make contact with them?
The property was posted. Yeah, yes ma'am.
Compliance by June 18th, 2023, or a $50 per day fine thereafter. Case number, or page 9, case number LCE 23-00585, 3018 Willow Ave.
Christy Kroll, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00585, and the address is 3018 Willow Avenue. The owners are David Charnays and Helene Charnays. The violation is Ordinance 4134, Section 1, derelict vehicle. Date of violation is February 14th of 2023, to be corrected by February 24th of 2023. Reinspection was on February 27th of 2023, and photos were taken on June 1st of 2023 and show the violation still exists. The city recommends that the property come into compliance by June 18th of 2023, or a $50 per day fine may be imposed and run until compliance is met. I have not had contact with these property owners, and I looked through the case notes of the previous officer and did not see any contact with him either. Yes, ma'am.
For compliance by June 18th of 2023, or a $50 per day fine thereafter. Page 10, case number LCE 23-00590, 602 West Crescent Drive.
Kaiser, Code Enforcement Officer of the City of Lakeland, case number LCE 23-00590, address is 602 West Crescent Drive. Owners listed as Paulita Negron. The violations of ordinance 5425, section 4.4.1I for fence condition. Date of the violations, February 14th, 2023, to be corrected by March 16th, 2023. Reinspection, April 17th, 2023, and pictures taken on June 5th, 2023 show that violations remain. I will make a statement that the male occupant, I don't know if he's the husband of Paulita Negron or what, but he called me this morning and said, hey, I made corrections. Go back, please, too. And this is the only issue that still remains as a violation. I let him know he would be getting 10 days to correct, and he said he would have it taken care of by this weekend, and he asked for a reinspection on Monday. So we have a feeling that that will be taken care of by then, but he is aware of what the recommendation was going to be.
Okay.
So at this time, the city would recommend compliance by June 18th, 2023, or a $50 per day fine would be imposed until the property is brought into compliance.
Well, recommendation, compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 10, case number LCE 23-00628, 4616 Jones Trail.
Christy Kroll, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00628, 4616 Jones Trail, and the owner is Kevin P. Cox. Violation is ordinance 4134, section number 1, derelict vehicle. Date of violation is February 15th of 2023, to be corrected by February 25th of 2023. Reinspection was on February 27th of 2023, and photos were taken on June 1st of 2023 and show the violation still remains. The city recommends that the property come into compliance by June 18th, 2023, or a $50 per day fine may be imposed and run until compliance is met. And I have had contact with this owner, and he advised that he could get it into compliance before that June 18th date.
I'll accept the recommendation for compliance by June 18th, $50 per day fine thereafter. Page 11, case number LCE 23-00669, 541 North Ride Trail.
Darren Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-00669. The address is 541 North Ride Trail. The owner of the property is the estate of Dorothy Sarver and Marvin Sarver. The violation is ordinance 3947, Chapter 3, Section 307.4, care of premises, overgrowth, open storage, and junk. The date of the violation was February 16th of 2023. It was to be corrected by February 23rd of 2023. Reinspection occurred on April 21st of 2023. Photos taken on June 1st of 2023 show the violation still exists. The city recommends the property come into compliance by June 18th of 2023, or a $50 per day fine may be imposed until compliance is met. And I have had no contact with the owner of this property.
Saw that it was posted, so I will accept the compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 13, case number LCE 23-00692, 1421 Grace Street North.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00692 for the address of 1421 Grace Street. Owners are listed in the agenda. I don't want to butcher the name, but it's really bad. Hard for me to pronounce anyway. Violations of ordinance 4134, section 1, derelict vehicle. Date of the violation is February 17th of 2023, to be corrected by February 27th of 2023. Reinspection on February 28th, and photos as recent as June the 1st show that the violation still remains. At this time, the city recommends the property come into compliance by June the 18th of 2023, or a fine of $50 per day be imposed and run until compliance is met.
Contact with them.
No, I have not.
Property posted.
No, it wasn't, but I think they did receive the mail, if I'm correct.
From that, it was mailed to the property address. I'll accept compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 13, case number LCE 23-00697, 5129 North Road 98.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00697 for the address of 5129 North Road 98. Owners are Lakeland Sons LLC. Violations of Ordinance 5425, Section 4.11.4.5I, surface maintenance and drainage requirements. Date of the violation was February the 20th of 2023, to be corrected by March the 2nd of 2023. Reinspection on March the 2nd, 2023, and photos as recent as June the 1st, 2023 show that the violation does still remain. We've met the property owner at the property, and they've started some progress. They tell me it will be done by June 18th. So at this time, the city recommends the property come into compliance by June 18th, 2023, or a fine of $50 per day be imposed and run until compliance is met.
I'll accept the recommendation of compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 14, case number LCE 23-00723, 766 Rockingham Road.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00723 for the address of 766 Rockingham Road. Owners are Barbara Dominguez and Marino Gonzalez Sardinas. Violations of Ordinance 4134, Section 1, derelict vehicle. Date of the violation was February the 20th of 2023, to be corrected by March the 2nd of 2023. Reinspection on March the 2nd of 2023, and photos taken as recently as June the 1st of 2023 show that the violation still remains. At this time, the city recommends the property come into compliance by June 18th of 2023, or a fine of $50 per day be imposed and run until compliance is met.
Is there any contact
I have not had contact with the owner.
with the property posted?
Gonna check this. It was not posted, but we're looking. It was posted, sorry.
Posted on the 25th.
One of my coworkers posted it for me while I was off.
I'll accept the compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 14, case number LCE 23-00780, 505 North Lake Ave.
Daniel Povey, Code Enforcement Officer for the City of Lakeland. Case number LCE 23-00780. Address is 505 North Lake Avenue. Owners are the estate of Catherine Petticourt. For violations, ordinance 4134, Section 1, derelict vehicle. Date of the violation was February 23, 2023, to be corrected by March 16th, 2023, reinspected on April 27th, 2023, and photos on June 2nd, 2023 show that the violation still remains. At this time, the city recommends compliance by June 18th, 2023, or a $50 per day fine be imposed and run until in compliance.
Contact with anyone at the property?
I was actually contacted by the homeowner this morning before the hearing that they are working to get that violation taken care of today. So I informed her that the hearing is still going on, but to call me once it's removed, and then we can close the case as needed.
I'll accept the recommendation of compliance by June 18th of 2023 and a $50 per day fine thereafter. Page 15, case number LCE 23-00788, 1507 East Main Street.
Daniel Povey, Code Enforcement Officer for the City of Lakeland. Case number LCE 23-00788. Address is 1507 East Main Street. Owner is Donna Stark. For violation ordinance 3947, Chapter 3, Section 307.4, care of premises, open storage, and junk. Date of the violation is February 23, 2023, to be corrected by March 2nd, 2023, reinspected on March 3rd, 2023. Photos June 2nd, 2023 show that the violation still exists. At this time, The city recommends compliance by June 18th, 2023, or a $50 per day fine be imposed. The property was posted.
Compliance by June 18th, $50 per day fine thereafter. Page 15, case number LCE 23-00802, 3815 South Florida Avenue.
Darren Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-00802. The address is 3815 South Florida Avenue. The owner of the property is POP Florida Properties, LLC. The violation is Ordinance 5425, Section 4.11.4.5.I, Surface Maintenance and Drainage Requirements. The date of the violation was February 24th of 2023. It was to be corrected by March 6th of 2023. Reinspection occurred on March 8th of 2023. Photos on June 1st of 2023 show the violation still exists. The city recommends the property come into compliance by June 18th of 2023, or a $50 per day fine may be imposed until compliance is met. I have had no contact with the property owner, and the property was posted.
Recommendation of compliance by June 18th, 2023, or $50 per day fine thereafter. Page 15, case number LCE 23-00807, 515 Whitehurst Street.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00807 for the address of 515 Whitehurst Street. Owners are Samantha Roth Knuckles. Violations of Section 86-2 Lakeland Code Lot Clearing Overgrowth. Date of the violation was February the 24th of 2023, to be corrected by March the 3rd of 2023. Reinspection on March the 6th of 2023, and photos as recent as June the 1st, 2023 show that the violation still remains. At this time, the city recommends the property come into compliance by June 18th of 2023, or a fine of $50 per day be imposed and run until compliance is met. I have spoken with the property owner. She's out of town, but she said it will be done by the deadline.
I'll accept the recommendation of compliance by June 18th, 2023, or $50 per day fine thereafter. Page 16, case number LCE 23-00835, 1203 Mayflower Drive.
Charles McClellan, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00835 for the address of 1203 Mayflower Drive. Owners are Susan C. Crawford. Violations of Sections 86-2 Lakeland Code Lot Clearing and Overgrowth. Date of the violation was February the 24th of 2023, to be corrected by March the 3rd of 2023. Reinspection on March the 6th, 2023, and photos as recent as June the 1st, 2023 show that the violation still remains. At this time, the city recommends the property come into compliance by June 18th of 2023, or a fine of $50 per day be imposed and run until compliance is met. I have not had contact with her, but it was posted.
Accept the recommendation of compliance by June 18th, 2023, or $50 per day fine thereafter. Page 16, case number LCE 23-00882, 1725 Park Drive.
Christy Kroll, Code Enforcement Officer for the City of Lakeland. Case number is LCE 23-00882, and the address is 1725 Park Drive. The owner is Carolyn Marie Thomas. Violation is Ordinance 3947, Chapter 3, Section 307.4, care of premises, overgrowth, open storage, and junk. Date of violation was February 28th of 2023, to be corrected by March 7th of 2023, and the reinspection was on March 8th of 2023. Photos were taken on June 1st of 2023 and show the violation still exists. The city recommends the property come into compliance by June 18th of 2023, or a $50 day fine may be imposed and run until compliance is met. I have not had contact with this property owner, and I looked through the case notes of the previous officer who didn't have any contact with them, but I did post the property.
Recommendation of a $50 per day fine thereafter. Page 16, case number LCE 23-00889, 2712 Providence Road.
Charles McClellan, Code Enforcement Officer for the City of Lakeland, case number LCE 23-00889 for the address of 2712 Providence Road. Owners are Martin Vogler Jr. Violations of Ordinance 3947, Chapter 3, Section 307.4, care of premises, overgrowth, open storage, and junk. Date of the violation was February the 28th of 2023, to be corrected by March the 7th of 2023. Reinspection on March the 8th of 2023, and photos taken as recent as June the 1st show that the violation does still remain. At this time, the city recommends the property come into compliance by June 18th of 2023, or a fine of $50 per day be imposed and run until compliance is met. I have not.
Certified mail was sent on May 3rd. Yes.
Recommendation of compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 17, case number LCE 23-00912, 723 West Myrtle Street.
Alex Gilbert, City of Lakeland Code Enforcement, case numbers LCE 23-00912, address is 723 West Myrtle Street. The owner is the estate of Edna Jones, violation of ordinance 3947, chapter 3, section 307, care of premises, overgrowth, open storage, and junk. Date of violation was 3/1/2023, to be corrected by 3/8/2023. A reinspection was completed on 3/9 of 2023. Photos were taken on, I believe, 6/1. For some reason, I didn't write it down. 6/2 of 2023. I'm sorry, I did write it down. The city recommends the property come into compliance by 6/18 of 2023, or a fine of $50 a day be imposed and run until compliance is met. I've actually had contact with the person living there time and time again. Finally, yesterday he called me and said he was too elderly to pick it up. So I actually got him together with some of our local charities that are around there that will help him. And it's the first time he asked for it, so that's the first time I actually brought it to him, because he said he was going to clean it up himself. So we have a contact with him, and he did know about the violation.
Then I'm going to order if there be compliance by July. Is it the 7th? I'm sorry, I don't have my. I'm not going to go with the June 18th.
Want to go for the
I'd like to go
days?
out.
Okay.
I don't think 10 days is enough.
July 8th.
Okay. July.
And I'll follow up with him today, make sure he made the phone call and all that.
Okay.
Right.
So compliance by July 8th, 2023, or a $50 per day fine thereafter. Page 17, case number LCE 23-00929, 730 Spicewood Drive.
Daniel Povey, Code Enforcement Officer for the City of Lakeland, case number LCE 23-00929, address is 730 Spicewood Drive. The owners are as listed in the agenda. For violation of ordinance 3947, chapter 3, section 307.4, care of premises, open storage, and junk. Date of the violation is March 3rd, 2023, to be corrected by March 10th, 2023. Re-inspected on March 13th, 2023, and photos on June 2nd, 2023 show that the violation still exists. At this time, the city recommends compliance by June 18, 2023, or a $50 per day fine be imposed.
Contact with the owner.
I have posted the property.
Accept recommendation of compliance by June 18th, $50 per day fine thereafter. Page 18, case number LCE 23-00959, 2915 South Lincoln Ave.
Aaron Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-00959. The address is 2915 South Lincoln. The owner of the property is the Ujima Investment Group, LLC. The violation is of Ordinance 3371, Section 9.02.1, regulations for open, unsecured, and unoccupied buildings. The date of the violation was March 6th of 2023. It was to be corrected by March 16th of 2023. Reinspection occurred on April 6th of 2023. Photos taken on June 1st of 2023 show the violation still exists. The city recommends the property come into compliance by June 18th of 2023, or a fine of $150 per day may be imposed until compliance is met. And I have not had contact with this property owner.
Where was the notice mailed to?
That was, I believe was certified mail, as I do not remember posting this property.
So 150 per day, the reason for the higher?
The higher fine is because it's an unsecured building.
I'll accept the recommendation of compliance by June 18th, 2023, or a $150 per day fine thereafter. Page 20, case number LCE 23-01131, 519 Carroll Ave.
Alex Gomez, City of Lakeland Code Enforcement, presenting for Daniel Sheets, who's out today. Case number is LCE 23-01131. The address is 519 Carroll Avenue. The property owner is Volk Real Estate Holdings Incorporated. Ordinance is 3947, Chapter 3, Section 307, care of premises, open storage and junk. The date of violation is 3/16 of 2023. To be corrected by 3/23 of 2023, and a reinspection was completed on 4/12 of 2023. The photos were taken on 6/1 of 2023, and I took one today at 6/8 2023. Showed the violation still remains. The city recommends that the property come into compliance by June 18th of 2023, or a fine of $50 per day be imposed and run into compliance is met. They did receive a certified letter and accepted it.
Recommendation, compliance by June 18th, $50 per day fine thereafter. Page 21, case number LCE 23-01294, 317 West Crawford Street.
Charles McClellan, Code Enforcement Officer for the City of Lakeland, case number LCE 23-01294 for the address of 317 West Crawford Street. Owners are Daniel Brittany Gordon. Violations of Ordinance 3947, Chapter 3, Section 307.4, care of premises, open storage and junk. Date of the violation was March the 30th of 2023, to be corrected by April 14th of 2023. Re-inspection on April 17th of 2023, and photos as recent as June the 1st of 2023 show that the violation still remains. At this time, the city recommends the property come into compliance by June 18th of 2023, or a fine of $50 per day be imposed and run until compliance is met. Not with the owner. There was a contractor there one day, and they said they was going to relay the information.
Was posted.
$50 per day fine thereafter. Page 21, case number LCE 23-01302, 525 Opitz Lane.
Darren Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-01302. The address is 525 Opitz Lane. The owner is Justin Deming. The violation is of Section 86.-2, Lakeland Code lot clearing, overgrowth. The date of the violation was March 31st of 2023, to be corrected by April 7th of 2023. Reinspection occurred on April 18th of 2023. Photos taken on June 1st of 2023 show the violation still exists. The city recommends the property come into compliance by June 18th of 2023, or a $50 per day fine may be imposed until compliance is met. I've had no contact with this property owner, and I posted the property.
I'll accept the recommendation of compliance by June 18th, 2023, or a $50 per day fine thereafter. Page 22, case number LCE 23-01492, 4325 Old Road 37.
Darren Kroll, Code Enforcement Officer for the City of Lakeland. This is case LCE 23-01492. The address is 4325 Old Road 37. The owner of the property is Bulaxima MAA LLC. The violation is ordinance 3947, Chapter 3, Section 307.4, care of premises, open storage and junk. The date of the violation was April 10th of 2023. It was to be corrected by April 17th of 2023. A reinspection occurred on April 18th of 2023. Photos taken on June 1st of 2023 show the violations still exist. The city recommends the property come into compliance by June 18th of 2023, or a $50 per day fine may be imposed until compliance is met. I have spoken with the property owner, and he is aware of what he needs to do to come into compliance, and he said it would be in compliance by the June 18th date.
Accept the recommendation. It's by June 18th, 2023, or a $50 per day fine thereafter. Right. I think that's everything. We're adjourned.